Uh, so good morning, Professor Chimni, and a very, very warm welcome to you. I think all of us have become like total aficionados of your exposition, especially those of us who heard you at the research methodology workshop at Nalsar. And I can say for myself personally that it's totally kind of given me a very new way of looking at. Could all participants please switch off your microphones? Uh, So this is I think the seventh or eighth workshop that we are having in this flying research kite. And primarily we're going to have someone who's kind of like seen, and I think the kind of response we've got for this workshop too is seen as giving you another way of looking at international law. As the whole purpose of these workshops is to get people to look at even established areas from very, very new angles. And that's why flying research guides. And it's in that spirit that we have Professor Chimni speaking to us today. And I can say for myself, Professor Chimni, that I don't know about the other candidates here, but after listening to you at the research methodology workshop, I kind of felt that the way in which I was teaching the globalizing world course, I would really need to rework it. I used to spend a lot of time on the law and justice component, but I think listening to you got me to comprehend how the globalizing world itself was a concept which needed much, deeper kind of digging. And the moment you make a connection between the two, you'll end up seeing things from a very, very different angle. So it's in that same excitement we thought that it'll be great if we could have you incite a number of young scholars to start looking at international law from a range of lenses, and not just keep doing the same standard form kind of thing. The entire set of workshops have been organized for that purpose. They are provocative in intention, in hoping that, because I genuinely feel that you need research to determine what research you should do. And we're hoping that your workshop today would catalyze further thinking and possibly more, adherence. Also, people who are already doing work, it will give them new, fresh perspectives from which to do what they have to do. So the format that we follow basically is that we have you speak for whatever 45 minutes to an hour, after which we generally take about a 10 minutes break to get people to reflect upon what you've said. And then we have a moderated discussion, that is, people type in their question and Professor Vasanthi would kind of assist you in telling you that these are the questions people are raising, so that you don't have to both read and reply. That's the logic behind it. And also so that, similar kind of questions can be clubbed together and one doesn't have to say the same thing again and again. So welcome, sir, and over to you.
Thank you so much, Professor Dhanda. Good morning to you as well as the participants. Thank you also for the very, very kind words. I hope I can do justice to them today as well. Once again to all the participants, and I was asked to speak on this theme, which is in front of you, research themes in international law, and I had titled it Old and New. So what I propose to do is to offer you a survey of some of the most significant issues which deserve our attention, or which deserve the attention of students of international law. But let me begin with some prefatory remarks. The first is the most obvious one of the exponentially expanding scope of international law. International law, as I said, regulates every aspect of domestic and international life. There is no area that I can think of where international law doesn't intervene in one form or another. Which also means that there are a whole range or a plethora of issues which can be researched by a student of international law. What I'm going to do is to simply flag, identify some issues which I think are important for students of the global south to research. So these are, in other words, merely illustrative issues that we can work on. But each individual can decide for himself or herself as to what area of international law is of interest, and then pursue their interest. The second sort of prefatory remark I wanted to make is again very routine nowadays, which is that speaking from a global south perspective, we need to decolonize research. And we, of course, we need to decolonize the entire discipline of international law. We need to decolonize both the research and pedagogy of international law. But today, what we are, speaking about is decolonizing research, by which I mean simply that as students of international law in the global south, we should try and see that we work on those issues which, or from those perspectives, which help us to further the interests of our own. To put it differently, what we should avoid doing is follow the fashion in research, and often this fashion is set in the global north. Are often issues which concern the global north more intimately than they can than the states or peoples of the global south. But because we find these these issues being spoken about, published in some of the leading journals of the world, we tend to, or we are inclined towards researching those areas which are finding a presence in the global north. I'm not suggesting, I must be clear, I'm not suggesting do not research those areas, because as you will see that there are some areas which wherever you are geographically located, you need to review, you need to research, but this is just a cautionary sort of remark, just a caveat so far. Your decision to research a particular subject or a particular topic of international law is concerned. A third prefatory remark was on a slightly different note, which is that I think each one of us has a particular skill set. So some of us, for example, want to look at the big picture. We want to study, world order level issues. Some others are more inclined to, take one particular slice of the problem and look at it in great detail. Some like to do theoretical research, others like to do empirical research. That is, each one of us have certain inclinations, certain interests, and a certain set of and a certain skill sets. I think we need to carefully evaluate very objectively our own skill sets, which calls for some degree of introspection, so that when you pick up a subject for research, your skill set matches the subject you are seeking or the topic that you are seeking to research. It is not as if you cannot upgrade your skill sets. You can very much do so. For example, if you have not paid sufficient interest to how to conduct empirical research, you can learn that. My own sense is that students of contemporary law schools in India have the requisite skill sets to pursue any line of research, whether it's theoretical or empirical. Uh, the canvas of reading is very wide and they're extremely knowledgeable. Comparing it to my generation, I see this generation of students much better, more talented, of course, and much better equipped to do research in law. It is simply a question of trying to identify to begin with, uh, what kind of work interests you and what kind of skill sets you have to pursue that research which interests you. Like I said, so that there is no mismatch, so that if you have no interest in theory, avoid doing theoretical research because it requires often familiarity with interdisciplinary literature, etc., etc. Remember that once you choose your topic for research, whether it's for doctoral purposes, postdoctoral purposes, or simply a line of research that you want to pursue, you have to stay with that theme or topic for a long length of time, and you can then sustain your research only if you are deeply interested in the subject. If you do not have, if you're not interested in the subject, or you find that your skill sets are not commensurate with the problem that you have picked up for research, then at some point it will start to bother you and perhaps act as a disincentive. So, so these are, some things that you need to keep in mind. One, that the issues that I'm identifying are just ones that I feel are important. There may be there is a universe of areas worth researching in international law out there, and you can take your pick. A second is just keep in mind that your area of research is one which concerns peoples of the global south, especially the marginal and oppressed sections. And the third was, some degree of introspection with regard to how, with regard to your own interests and skill sets. Now, let me, with those few remarks, turn to what I think are the central themes of our time. I mean, these are themes which all of us should be interested in, but many of you may wish to research as well. These are central themes in the sense that these themes, in my view, transcend the north-south, global-south divide. These are themes that concerns, as I said, each of us. So I've identified 4 central themes, which I think all of us need to engage with at some level, and some of us may wish to pursue, research on them. The first, and none of these require much explanation. The first is, of course, the climate crisis. Those of you who've been following the newspaper would know that just 6 days ago, I think it was on the 9th of August, that the International Panel on Climate Change issued its sixth report based on physical sciences. and which confirms the worst fears that we need urgent action on the climate change front, if we have to ensure the set in the Paris Agreement of 2015. It also confirms that it is human activity which is the cause of the climate crisis. But beyond the consensus on these, fundamental issues, of course, there are still climate skeptics, etc. And some of them were, in power, are in power in different countries of the world. But by and large, there is a consensus that there is global warming, and this could have very, very serious implications wherever you are geographically located, and we need to find answers to this. And the answers to this, have to be searched at an interdisciplinary level. Answers are being provided by scientists, by technologists, by geographers, by biologists, But law also has an important role to play, especially in ensuring that in dealing with the climate crisis, global North does not pass on the burden to global South nations, neglecting the common but differentiated principle, which is the foundational principle of international environmental law, in particular international climate law. There are already a range of issues being raised in respect to the climate crisis, which are captured by terms such as carbon colonialism, green grabbing, and so on, which suggests that the global North and its corporations, in particular its corporations, are using what is called climate offsetting to keep to their own targets of net neutrality, but in the process are harming local communities, indigenous communities, and peoples of the global South. Now, so this is an area which is crying out for research. We have had some good scholarship. So on the front lines of international climate law is the work of Professor Lavanya Rajamani, who is presently, I think, teaching at Cambridge University. And there is, of course, a lot of social science scholarship that is emerging. But my sense is that the climate crisis deserves much more attention, even from an international law perspective. I haven't seen detailed commentaries of international climate law. I won't get into too much detail of these issues that I'm going to flag, but I'll be happy to respond to them in the Q&A session. As I said, I'm just talking about, for the present, the big issues that are under-researched, that have not received the kind of critical, sustained attention that they deserve. So climate crisis is one. Because it affects life on planet Earth, it even threatens the extinction of life on planet Earth. So we cannot but engage with this issue. But a crisis of equally, to my mind, which is equally grave, equally problematic, equally disturbing, is what I call the digital crisis. Now, the digital crisis arises, as we all know, from the emergence of digital technologies from the mid-80s, eventually leading to what is now called the fourth industrial revolution, and the term digital technology encompasses a range of technologies varying from artificial intelligence to to robotics, to cloud analytics, and so on and so forth. And I think all of you are familiar with the scope of digital technologies. Now, there are two aspects of, I think, the digital crisis which have not received, sufficient attention from scholars in the global south, including India. Of course, there is some research on how you can use AI to address the question of digital justice, which is used narrowly most of the time to talk about justice and the judiciary, dispensation of justice by the by the judicial arm of the state. There's also some discussion about the regulation of artificial intelligence. But my sense is that the crisis goes much deeper. The digital crisis today is about how digital technologies can threaten the very notion of the self, that digital technologies harnessed by digital platforms, gigantic digital platforms like Facebook Incorporated or Google or Amazon. Once these technologies are harnessed by these giant corporations, they can use this data, which emerges, or the big data as it is often called, to manipulate the self. By which I mean is that they can use your own labor, that is your own efforts, to generate data, which can in turn be used by digital platform, by digital companies, by digital corporations to manipulate you, and this simple evidence of manipulation we know is known to all of us. If you search for some terms, some themes on, say, Google, you will find that at some point it on its own offers you more items on that theme, because what is in use, because what are used are algorithms to generate this data, and these algorithms are then able to be sorted out and sorted out in a manner which can feed you information which the algorithm believes you are seeking. There's a whole lot of literature on this. A good example is Professor Zuboff of Harvard University's book on surveillance capitalism. This surveillance is not surveillance done by the state, and I'll come to that, but surveillance done by corporations to monetize the data that results from it, to make profit of the data that is the outcome of our individual uses of digital platforms. And the second aspect is, of course, surveillance in the ordinary sense of the term, of which a good manifestation we have seen is the use of the Pegasus military level spy software to gather information on individuals belonging to nearly all sectors of domestic life. So my sense is that together the digital technologies threaten not only routinely our core human rights, whether it be the right to privacy, whether it be the right of freedom of expression. We see the ongoing debate between Twitter, for example, and some opposition leaders in the country. So not only does it threaten core human rights like privacy or freedom of expression, but like I said before, my sense is that an unregulated digital world can mean that tomorrow corporations can actually exercise effective control over you, over an individual, by manipulating the individual through data, by manipulating the individual through information. And if you've been reading around the digital problem, you'll realize that further advances in digital technologies are on the way, and including the creation of new kinds of virtual worlds. For example, just a month ago, that Mark Zuckerberg of Facebook gave an interview talking about, I think it was metaverse is the word that he used, which would be a new virtual world in which you can more actively participate, be seen, perceived as participating in meetings, in community level projects. So this is a vast subject and deserving of a separate lecture. um, um, I don't know whether I'm being able to do justice to simply laying out the scope of the digital crisis. But my sense is that even more than the climate crisis, the digital crisis calls for serious research, which is not simply confined to the use of AI in the by the judiciary, which deserves attention, of course, which is not simply about regulation of AI, but of regulation of the digital universe at the global level. At present, there is no global regulation of the digital universe. There is no international organization which deals with digital technologies. The advances which are being made at regulating the digital world are either at a national level, say in the US, or at a regional level in the European Union. For example, in April 2021, EU has come up with a proposal on the regulation of artificial intelligence, which includes, of course, use of face recognition technologies, biometrics, and the rest. So there is some development in some parts, but there is almost no serious research from a global South perspective, from the perspective of marginal and oppressed people. For example, what does the digital crisis mean to asylum seekers and refugees? I have no time, but the digital technologies are already being used by what is called the border industrial complex to keep out asylum seekers in the global north. And this is being documented. There are some reports out by researchers in the global north, but we have not been able to still research this area adequately. A third, of course, central theme of our times is the post-COVID crisis, which doesn't require elaboration. The post-COVID crisis is a simple one. Because of the damage COVID or the 19 or the pandemic has caused to the economies of the global South nations, it is very clear, and there is wide consensus over this, that is poverty eradication program, that is of the global South nations, has suffered a serious setback. Even the World Bank admits that nearly 150 to 200 million people are going to go back into poverty. My own sense is that these figures are underestimated because they use criteria, poverty criteria, which has been sharply taken to task by a number of learned people. So what we have in the post-pandemic era is growing poverty, And this poverty, the consequences of this poverty are going to be accentuated in some way by the climate crisis. So the climate crisis, again well known, the burden of the climate crisis falls more on the poor, the marginalized sections of any society, particular in the global south. So, in the post-COVID crisis, what kind of changes that we need to bring about in international law? For example, in international economic law, in international trade law, that can help the global South nations to overcome the setback it has faced. I would refer you here simply to and I think I may have mentioned this in my earlier talk, to an excellent lecture by the UN Secretary General Antonio Guterres, called the Mandela Lecture, which he gave in June or July last year, calling, analyzing this post-COVID crisis and calling for a global New Deal, which would require, in his own views, to give up, to restructure what he called colonial trade, colonial investment patterns, and so on. So the post-COVID crisis and the possible response from within international law is a subject which I think requires some degree of attention. Um, then there is finally, in the central theme, there is the democratic crisis. And the democratic crisis, I think all of us are aware of, the rise of nationalism and populism all over the world. Or rather, I would say nationalism, populism, and authoritarianism. And this is a global phenomena. The leading democracies are impacted by this. And again, an issue which transcends the global north and global south divide. I have a student presently researching the area of populism and international law, trying to identify what kind of policy changes populism leads to in the world of international law. In what way do populist leaders approach different areas of international law, whether it be human rights law, migration law, environmental law? You can think of Donald Trump and his approach to different areas of international law, and you'll realize that the rise of populism is bringing about a whole range of changes in the world of international law, and it's also leading to a democratic crisis. And the earlier view advanced by Thomas Frank and others that that there is today a principle of democratic entitlement which has emerged, undergirded by the principle of free and fair elections. Those kind of notions are today being questioned through the rise of populism. So these are the four central themes that call out for research: the climate crisis, digital crisis, post-COVID crisis, and what I call the democratic crisis. And each of this has very grave, as I said, implication for each of us. For each of us, there are grave implication. And if we don't research it as students of international law, from the international law perspective, of course, then who would? But let me then go on. Like I said, I'm giving you almost like a laundry list, a survey of some of the themes that, in my view, need to be further researched from a global South perspective. So let me go to certain other key themes. You know, so among the two other key themes that I think that call for research, and which we probably already aware of, conscious of, and and have examined. One is that the area of international investment law. The area of international investment law, which emerged quickly in the era of globalization, is already in crisis. Uh, Both the normative consensus is fractured, as well as there are serious questions about the interstate dispute settlement mechanisms in relation to investment disputes. We in India ourselves have seen what kind of implication the ISDS mechanisms can be had, which most recently has compelled the government to go back on the retrospective tax which had been imposed. We are involved in a series of cases, and which led to the call for renegotiating all the bilateral investment protection treaties that India had entered into. So international investment law is in a flux. It's been debated in very many forums, including UNCTAD, including UNCITRAL. And my sense is again that although we have some very leading experts on international investment law, for example, Professor Prabhash Ranjan, who's now with Jindal, has looked at it. I think there is a need for much more research, because there are contentious issues on which there could be a diverse set of understandings, and therefore we need more voices. We need more voices on this. The other key theme is the migration and refugee crisis. This is another area which is crying out for is crying out for crying out for crying out for serious research, both on the domestic plane as well as at the global level. While I've seen a number of writings say on what the status of refugees are in India, I still feel that many of these do not look at in great depth at refugee law, or on the global refugee crisis. So these are two other key themes. Apart from those are central themes of our time, ones I mentioned before, because it involves all of us. These two, international investment law and migration and refugee law, also have a global dimension, and they but they require much more critical research from the perspective again of the from the global south nations. Then there is a need for what I call doctrinal critiques. And this, let me reiterate that I'm flagging all the issues, all the themes that I think are important, and then we can have a conversation about these or any other that you think are important. The reason I thought I will do a survey is because, like I said, each one of us are inclined, towards different kinds of subject areas, and different modes of research. So that if you have all these themes in front of you, you can, which in my view deserve to be studied further, you can then pick and choose whichever one you wish to. So far as doctrinal critiques of international law are concerned, I think there are three areas which call for much research. Uh, Now, I may mention that uh, from a global south perspective, TWAIL, or the third world approaches to international law, has done a very deep critique of some areas of international law. For example, the history of international law, also of the consequences of the working of international economic law, and so on. But what TWAIL hasn't done, or if I may say so, what we haven't done sufficiently, is to analyze what are the traditional areas of international law, which are the areas, which are the doctrines which have the most bearing on the practice of international law. So we are often told that, TWAIL can keep critiquing the history of international law, etc. But but the world of practice of international law would continue to go on as it has before. So nothing would change. So insofar as practice before international tribunals is concerned, whether the ICJ or the WTO panel or appellate body or the law of the sea tribunal or the international commercial arbitration, nothing would change there in terms of how they approach international law issues, how they adjudicate, because so far as the basic doctrines of international law, which are relied on in these forums, these have not been these continue to do the work that they were doing in the past. And these are the areas of sources of international law, which perhaps has been relatively more adequately addressed by global south scholars than the other two. But the law of state responsibility, where we are celebrating I don't know if I should say we are celebrating, but there are some who are celebrating the 2 decades of the adoption of the articles on state responsibility drafted by the International Law Commission. If you look at the recent publication, recent write-ups on EJIL talk, they look at different dimensions of the law of state responsibility, which were adopted in draft articles of which were adopted in 2001. Likewise, the international law of jurisdiction, in its whole host of dimensions, has received almost no analysis. How did the international law of jurisdiction evolve? What are the material reasons for it evolving in a particular direction? What is the relationship with colonialism? What is the relationship with neo-colonial structures, and so on? These aspects of have not been studied. In short, the doctrines of international law have received almost, I would say, no attention in terms of offering an alternative vision, in terms of offering an alternative reading, an alternative interpretation of of them, and unless we are able to provide this alternative critique, or alternative understanding, alternative vision, we will not be able to displace what I call mainstream international law. So if you want to change the textbook on international law, then you have to offer an alternative vision. This cannot be. I'm not suggesting that this can be done tomorrow or even in the next decade. But if we begin to pay attention to these doctrines from a global south perspective, then we would be able to begin that process, which will eventually lead to the reconfiguration to the restructuring of these doctrines. Now let me come to my final sort of set of issues. The first is issues relating to human rights. Now we know that human rights has emerged as this overarching theme so far as the values of fairness and justice in international law is concerned. That is, everybody, every group, every community which is upset with international law has turned to human rights uh, to not only find its voice but also to adopt a set of norms which responds to the concern of the of particular groups within international society. And that is the reason why you will find that nearly every group, if one may call it that, in the world has a separate, apart from the general conventions on human rights, every group nearly has a separate, oppressed or marginalized group has a separate convention to itself. So there is the CEDAW convention on elimination of discrimination against women. There is the Convention on Rights of Child. There is the Declaration on the Rights of Indigenous People. There is the Convention on the Rights of Persons with Disabilities. There is the Declaration on the Rights of Internally Displaced. Displaced. There is now a convention on the rights of peasants, a declaration on the rights of peasants, and so on. So every group has a right, has a convention or a declaration to itself, uh, and and of course, the issue, insofar as human rights law is concerned, or the role of human rights in the global order is concerned, is being actively debated. With some suggesting that we need to put all our eggs in that basket, and others suggesting that the human rights discourse is actually has very limited objectives, and but by its imperial aspirations is actually displacing the notions of displacing the notions and struggle for justice. If you look at, for example, the recent writings of Samuel Moyn, he makes this argument that human rights. The political theorist Wendy Brown makes a similar argument that there is a dark side, in other words, to human rights. So those issues are there, they'll continue to be researched. But I felt there are two that I wanted to flag. One is the theme of caste in international law. Um, I did have a student in JNU many years ago who did a thesis on this. But my sense is that within international law literature, and I'll come to that, while there is emerging literature offering a class perspective, a gender perspective, and race perspective on international law, we still are, the literature is very, very thin on the theme of caste and caste in international law. Or to put it differently, can international law processes be used to deal with caste discrimination, caste oppression? And this is, of course, a particularly important theme in the context of India. But now it's become become a global level problem, because it is said that the Indian diaspora has taken caste to the rest of the world. And you may recall there were efforts. I don't know whether they eventually were culminated in the adoption of the proposed act in the UK, prohibiting caste discrimination, etc. Uh, Tuel itself has been criticized for not looking at the caste question in the same way as it has looked at the class, gender, and race, and the race questions. So, caste, this broad theme of caste in international law, um, is another area which I think needs to be researched. And of course, we have the profoundest insights and the corpus of writings of Dr. Ambedkar. I don't think his writings his rich writings have been sufficiently mined as yet, and how he dealt with the caste question in his own lifetime. These have not been sufficiently studied for their implications on international for rather international law. The other aspect of human rights that I wanted to sort of underline is the rights of minorities. Uh, Now, so while there are conventions so far as many of the marginalized groups are concerned, for example, there's a convention on the rights of women, convention on the rights of child, convention on the rights of persons with disabilities, etc. There is no convention on the rights of minorities. There is the 1994 UN Declaration on the Rights of Minorities. This is soft law. This is, of course, non-binding text. But a convention has not been adopted, partly because of the debates around the meaning of the definition of minorities, with some nations even not accepting that they are minorities. I think France is one such nation which does not uh, like to deal with the category called minorities. But with the rise of populism, hypernationalism, authoritarianism, the rights of minorities are in issue globally. This is now a global phenomenon. And I think the rights of minorities requires to be studied both from a theoretical and empirical standpoint within the domain of human rights. All other aspects are equally worth study, but I thought I'll sort of single out these two. One is the caste question, and the other is the rights rights of minorities. Uh, the last sort of set of issues are pertain to different theoretical perspectives. Now here we've seen in the post-Cold War era a whole range of critical theories emerge. Uh, uh, it's the feminist approaches to international, of course, the third world approaches to international law, what are called the new approaches or the critical legal theory approaches to international law. There are post-structuralists, post-modernists. There are a whole range of critical theories that have emerged. Uh, but again, while these theories have emerged, there is not a critical mass of literature uh, which is which is continuing to analyze these different approaches. For example, on the feminist approach, the very the the person who carried out who pioneered the feminist approach, Hilary Charlesworth herself writes in an essay which was titled "Talking to Ourselves," by which she meant that that feminist approaches, the conversation around feminist approaches happens, within those who are the propounders of the feminist approaches to international law, or a small community which is devoted to the feminist approaches, that it has not been, again, not been able to become part of the larger conversation of international law in the way it should have. So that, again, if you go back to the doctrines, there is no sustained writings on the feminist approach to, say, the sources of international law, or the international law of jurisdiction, or international law of state responsibility. So, in other words, while these approaches have emerged, they have had an impact without doubt. They have carved out a presence, even if it is a peripheral presence. But if we need to take these different approaches forward, they require further reflection. They require the application of these approaches to different areas of international law. They require essentially to be mainstreamed, so that you cannot discuss any issue of international law without bringing in class, gender, race, and I would add caste. This has become particularly important because my sense is, and I don't have the time to argue this out with you, I want to conclude so that we have enough time for conversation. But my sense is, what we are seeing happening in the world is that the world is big divide. World is, of course, at the level of the logic of territory, divided into whatever 190 odd sovereign states. But it is now on the social plane is being divided into two: the global rich and the global poor. That is, there is clearly a global class divide. And I'm here using the category class in a composite sense. That is, the category class includes the gender and race divides. So there is a global class divide that we can easily see emerging, especially in the post-pandemic era, where yeah, even in the global north, you are seeing that even their middle classes are finding themselves marginalized, with fewer and fewer access to jobs or resources that they had in the past. And so we cannot understand this global divide uh, unless we use, unless we turn to some of these theoretical, the new theoretical approaches with their distinctive epistemological contributions. The last theme that I wanted to mention, of course, is that which is something that's close to me, which is to take the third world approaches to international law, which is just one of the critical approaches. We need to take that forward, because I believe that TWAIL is able to bring together the insights of the class, gender, and race perspectives. It is able to bring those perspectives together, draw on their insights, and able to articulate its understanding of different themes and areas of international law. But in order to take TWAIL forward, we also need to urgently look at the gaps in TWAIL scholarship, the both theoretical and empirical gaps. For example, TWAIL, as I said, has been critiqued for not taking the caste question as seriously as it has taken the gender, race, and class question. And therefore, in order to take TWAIL forward, we want a new generation of TWAIL scholarship which takes stock of where we are, critical stock of where we are, and then moves forward not only to attend to these new themes and areas of international law, but also to enrich the epistemological insights that the first and second generation of Twin scholarship has offered. So let me then conclude by saying that I hope this is helpful. There were various ways that I could have touched on these question of themes and issues, but I thought it may help to simply identify what, in my view, are some of the key issues of international law, which require to be researched and researched. But let me add that at the end of the day, it is for you to decide, each one of you to decide what area that you wish to research, and you should follow your heart in that sense, because as I said at the outset, research, you have to, in order to do serious research, you have to stay with a theme for a few years, and you cannot stay with a theme for a few years if you're not interested, if your heart is not there. So please pick the theme carefully, so that you, keeping in view your own skill sets. And the final sort of point that I want to make is that I feel, and that's more advice I give as simply a senior citizen, which you can keep aside, which is that do not be in a hurry to publish. And that's, while you are researching. I know the pressure of our times that, you need some publication just to get a job. Um, and if you're not publishing, you don't seem to be part of that community which is having a conversation over, different aspects of international law. But I would say try and balance both your more immediate sort of your immediate goals with your longer term goals. So once you have met your immediate term goals of having some publications which are important from the perspective of getting tenure, or uh, getting an entry into the academia, try and publish only when you have done adequate amount of research. In my understanding, one good art, I wish somebody had told this to me, the beginning of my own journey. That is, one good article is worth 50, which are just which are ordinary pieces. They may be good pieces, but which do not advance the conversation in any particular on international or any particular theme in any distinctive way. Uh, so, so in other words, rigorous research always rewards, always pays. But like I said, I understand that you need to balance that. But try and see how best you can balance this urge to publish uh, with the need for the need for much more rigorous and grounded research. I'll stop there. I hope I made some sense and I have had offered you some uh, reflections which are useful. Thank you all for your patient listening. Thank you.
Uh, Thank you, Professor Chimni. As always, like I think we always get uh, a new way of looking at things every time I hear you. We have been for a long time, trying to get all of our law students to start to look at their the various areas in which they are working to also see the theoretical dimension to it. But listening to you today and the emphasis that you put in on that, okay, there has to be this matchup, not just with what the student is passionate about, but also what the student is comfortable with. What is their, what is the skill set that they have, and what is the skill set they wish to develop. I think for me, that's been a very important cautionary note that, as you are trying to mentor people, you should try to also get each one of them to be the best versions of themselves rather than, like superimposing some kind of a model that they need to absolutely follow. I mean, this is not in relation to, I mean, the general comments that you've made and the structure of your talk, I think was extremely useful for each one of us. And I'm hoping that the 10 minutes break, when we come back and people put in their questions, we will be able to discuss, the central themes that you had put out on climate change, on the digital divide, or the developments that have happened in the digital world, the whole area of, I mean, the post-COVID world, as well as I think the agony each of us is facing today as to whether we are, all the things, all the notions of democracy and rule of law that we had grown up with, have they become like passe? Are they no longer relevant? Or what is it? How is it that one can be re-energizing them? I was also very much taken up by that point you made on that unless and until you provide some kind of a replacement for the sovereign version of international law or the North version, and in its traditional areas, like to think in terms of that, okay, reconstruct international law foundationally, unless and until we think that from a third world approach or from the South approach, you're really always going to be on the margins. You are just going to be an alternative that is spoken of, but you don't really become a part of the main discourse. And I think that's an extremely important insight that each one of us, in whatever area we're concerned with, needs to worry about. So I really want to thank you for that, because in a similar way, like whether we talk in terms of feminist thought or whether we speak, if you are not going to be, the ones who are actually creating the structures on which things are built, you are always going to be a marginal presence, somebody who's accommodated and maybe mentioned and ticked off, but you don't really change the way in which the world is thinking about issues. And I think that's something for us as scholars is really important to worry on. On a very personal note, when you spoke in terms of the whole area of human rights, and because I have worked quite substantially on the inclusion of disability rights, or the Convention on the Rights of Persons with Disability, and how the human rights discourse can be. Professor Chimni, I think your mic is on.
Okay. Sorry.
No, I think that's kind of causing the echo. That's why.
Okay.
And I can't turn my camera on again, so my voice is only speaking with you. So, I just wanted to sort of share this with you, because it's a more recent kind of concern I've got. Amongst the things that one had worked very hard on was to get the legal capacity of persons with disabilities, especially persons with intellectual and psychosocial disabilities, to be recognized in international law, and hoping then therefrom, you would be able to maybe start on conversation in municipal laws, in the ways in which national legislations are formulated for persons with disabilities. And after about a decade of working on that, I've kind of recognizing the fact that the whole concept of legal capacity as such is a concept which, the moment it includes, it automatically excludes. And you can keep, this is an ever and ever game that you get, say 20 people in, you'll still find 40 out. You get those 40 in, you'll have another 10 emerging. So whether we need to be working on some concepts of, where you talk in terms of inclusion, but not in legal constructs which were made by people of privilege. I mean, it's a kind of thought which I am now encountering, and then seeing the limitations of the whole realm of human rights. So thank you so very much for flagging that out in the way in which your issues were put out. I sort of, we'll have that 10 minutes break. You could also catch yourself a cup of tea or coffee, and we come back. In the meanwhile, they'll have their questions, and Professor Vasanthi takes over from there in coordinating the discussion and the other conversation that is there with you and the participants. Thank you so much, sir.
Thank you. Thank you, Professor Danda.
Time might become too much of a, because the students will keep typing in the questions and it becomes difficult to juggle. So I will pick up the questions, put them in some kind of a cluster, and I will be asking the questions, and then you can respond to them. So the first question that we have here is about, what are the topics that one can, how does one decide on a topic? So I think the question leads to, how does one choose a topic? Because the problem has been the students either find it too wide or too narrow. So there's a very specific question on how can we empower a disabled child through international law and primary schooling. So that becomes a very, very, very specific question. On the other hand, international law questions tend to be very broad, where students are often asked to narrow down. So I think the question would rather be, how does one find that balance between too specific a topic and too broad, almost like an area that you're trying to research on?
Yeah, no, thank you. No, I think that's a very good question. And I think all of us struggle with finding the balance. I struggle to do that even today. So my sense is that there is no formula there. There is no formula which will allow you to, sort of feel reassured that the topic you have chosen is neither too broad or too narrow. My sense is that as you research, as you begin your research in particular areas, you will be able to find the balance over time. One sort of criteria that you may use is to that when you, in order to find this balance, is that review the seminal literature in the field. By seminal literature, I mean the principal sort of publications which are referred to by any scholar in that domain area. Read these and see what kind of balance they have struck. That is, that you don't often have to reinvent the wheel. You have some models in front of you in terms of earlier research. The second thing is to see what are the gaps, which is the traditional way of arriving at our topic. That we review the seminal literature and then decide that there's a particular area or perspective, which has not received attention. That is, there is a gap in the literature, or there is, say, the global South perspective is not reflected in the literature. So identify what the gaps or the lags are, and then write your research. Then write your research proposal. In short, there is no formula. Then the last thing I just want to remind you that, again, your own skill set and inclinations are very important. Like I said, some of us want to look at the big picture, and some like to look at the narrow picture. Some like to do many things. There's that famous example that Isaiah Berlin gave of the fox and the hedgehog. This is deriving from the Greek myths. The hedgehog does one thing. So we have scholars in the field of law who work on the same area throughout their lives. That's the hedgehog. And there are those who are foxes, who look at a whole range of themes in their lifetime, because that is what their inclination is. So that again is a very important to keep in mind, vis-a-vis, of course, your own inclinations and skill set.
So if I can follow that up with a question, and this is largely because this is something the students often ask us when we say identify the research gap, and I think that from a student's point of view, it's not so easy. And maybe you would like to speak a little more on this, because when you say seminal literature, then it tends to be the most authoritative literature rather than the provocative one, like your own writing on Twain. At that point might not have been the seminal one, which, where you tend to only look at the dominant position. So how does one then, maybe you would want to speak a little more on that.
No, so you're so right. How do we decide what the seminal literature is? First, of course, is the most ordinary way of doing that is to look at the most cited literature in the field. For example, on X question that you are researching, say go to Google Scholar and type in that theme, and you may get some literature which has been cited, say 5,000 times. Then obviously there is something about that scholarship which is very significant in understanding that domain area or the field. So that is one way of trying to find the literature which is most frequently referred to or cited by scholars in a particular field or domain area. Second, as I mentioned, that often, as you rightly said, this may not give you the complete picture because very often most of the similar literature emerges from the global north. And that is the very logic of domination and hegemony. The universities of countries which are powerful countries are often seen as the best universities. It is their professors whose publications are most often cited. So when the British Empire was at its height, it was Cambridge and Oxford which were the most important universities. And now with Pax Americana, which is also going, with Pax Americana, we had the Ivy League in the US. And it is the scholarship which emerges from these universities. And the other scholarship does not find a sufficient weight and presence in the field. And that is where, you have to try and search in a different direction, and one way of doing that is to look at, now that you have critical literature, earlier, so for example, on X question, you may not find sufficient feminist scholarship. Then one way is to go to the feminist scholarship, even if it's not very highly cited, to see whether they have any reflections on that, on that subject. Nowadays, this is not very difficult to do, given the internet, and also, often communicating. I think, communicating with the people who are working in the field can sometimes also help you identify, a literature which, although is not seen as seminal, is actually seminal because it offers you a completely different take or a different perspective. So yes, so there are different ways of sort of doing this. At a practical level, therefore, it may be good to, before beginning, to make a short bibliography of readings based on these criteria. And that would help you both get a sense of the entire field and range of perspectives, as well as the gaps that continue to exist. So that's the way I do it myself, and often, one final point, often you may not find any critical literature. There are still areas of international law where you will not find that any of these critical approaches have offered their thoughts or their reflections. And we need to do that. And that, and that calls for many things, one of which is that you have to be, you have to be not, you may have to be risk averse, not be risk averse. That is, I myself have recently written things where I fear I'm going to be trashed. I'm going to be told all this is nonsense. And I said, no matter, we'll do it. Because somebody has to throw that first stone. Somebody has to initiate that critical conversation. And we are aware that all the time we may not get it right. We may not be able to offer, but we still need to do it. So all these are things that you need to keep in mind. But at the end of the day, and I will repeat that, what we want is rigor in the research. It doesn't mean you get any idea and you'll then write a blog on it, or you get any idea and then you want it published. Spend sufficient time thinking about the problem. And my sense is once you spend have a sustained engagement with a problem, you will not find it difficult to either identify the seminal literature or the gaps, whether, etc. I don't think it will pose a very big problem.
So a follow-up question. I know I'm diverting away from the questions that have been put there, but I think one other thing that is coming out strongly in what you're saying, but you haven't explicitly said this, which also when we say that there needs to be a theory to your proposal, we are talking about your politics as a scholar, but somehow we're very uncomfortable perhaps with talking about it as politics. Would you want to say something on that?
Yeah, so there is this old debate between the law-politics divide, that doing law is something different from doing politics. But I think this whole argument has been sufficiently critiqued, and you'll find a lot of writings on a critique of the law-politics divide. We all know there is no such thing as the law-politics divide. At a very crude level, law sort of codifies the interests of powerful social classes, and it's not very difficult to demonstrate that. But my own sense is that even those who want to stay with the divide, the relative divide, I don't think anybody believes that law is not politics. But some people more so, and some people less so. I have personally no issues with that. I think very good positivist scholarship is better than poor theoretical reflections. So well-grounded, rigorous empirical research is most welcome. Very good commentary within the positivist framework is most welcome. My sense is that often the problem is we have more of the latter than of the former. So even if you look at the Constitution of India, I mean, its interpretation, and the thought that went behind it, its relationship to the freedom struggle is now emerging is coming to the fore because political theorists, political philosophers have taken to reflecting on it. So my sense is that both, I have no issues. I'm personally political. I don't believe in the law-politics divide. I carry my politics on my sleeve. But two sort of cautionary remarks for those who are young teachers. I don't carry it to the classroom. There are two things I don't do. I don't go to the classroom only to teach my way of thinking about the law. That's one. And secondly, I don't know even whether one should even state this. Whatever your ideology is, the principle of non-discrimination has to be followed so far as your students are concerned. That's what I mean by not taking the law, your politics to the classroom. Because often what may happen is that because somebody shares your ideological predilections, that student or that individual tends to, So there are these other issues which come with this assertion of a strong law politics linkage, which all of us need to collectively reflect over. How does it play out? How does it play out in your scholarship? How should it play out in the class, in the classroom? I often have students insist on working with me, with whom I have no agreement on anything. We disagree on almost everything, and yet they say no. So I said no issues. As long as you're internally consistent and coherent, this is your project, you want to articulate it. When you publish it, I'll critique it, but that is separate. But I'm not going to say no, I will not in any way be be associated as a teacher with it. So there are these boundaries that one has to draw, but maybe that's another subject for another time.
Just had a one sentence intervention because of the fact that opinions of jurists have the kind of source of law, especially in international law. I sort of always wonder that whether the politics of scholarship or who gets published and who's seen as the established scholar is much more, relevant in the context of international law. I mean, I also take the same line that, no, I have a politics and I will teach according to that politics. I will have a declared thing on it, but I'll give you a fair hearing on whatever is your politics. That's the way one sort of sees that bit I get. But I think you mentioned it earlier too, that somewhere, especially students researching international law, need to be cognizant of this fact of that there is a certain body of writing which continuously gets privileged, and there are others which are somewhere sidelined. So can it be your way of, doing your research and writing that you ensure that this inequity is in some manner corrected, or at least you're conscious of it? It's just adding on to what you'd said earlier, but I just thought it may be worthwhile to make that connection.
No, I think that's an excellent point. And as you rightly said, in international law, it has greater salience because, as they say, international law is what international lawyers say it is. It is not like domestic law. In other words, the academia in international law plays a much greater role, a much more critical role than it plays in the within the domestic arena, and therefore you need to be aware. And then there is alongside that the fact that those who have the power, those who create the journals, those who create the publication houses, they would do a lot of gatekeeping. And it continues to be done. That gatekeeping continues to be done. It's not very easy to get published in the leading in the leading journal. But my sense is that in some ways the world is changing, and that it has become very important, unlike in the past, for a variety of reasons that I won't go into, for the academia and the global north to be at least appear as listening to scholars in the global south, and some form of token presence in their leading journals. But I think we need to be sort of cognizant of our own responsibilities here. Why is it? I asked this question when I went to NUJS many years ago. So why is it we cannot collectively produce a leading journal? So we do have. So let me not sound as if I am not recognizing the importance of some of our journals in law, which includes, say, the Indian Journal of International Law, or the Indian Law Institute journal, and I think some of the very good journals being brought out by law schools today. The quality has gone up by leaps and bounds, without doubt. Yet, what is it that is preventing us? Is it simply the power relationship, or are there other factors that come into play, that in some ways do not allow us to produce a set of first-rate journals? It shouldn't be one journal. You take international law, 90% of the journals, I'm saying roughly, are coming out from the United States. And all these are student review journals. The only journal which is not run by students is the American Journal of International Law. All the rest are run by students. So what are the protocols, etc., which have been put in place to ensure the quality of the journal? Again, so there is a responsibility at our end that we need to think about. Although things have improved dramatically, like I said, the quality of the legal mind, the quality of the law student is as good as anywhere in the world, if not better. But yet the ecology of the institutions, etc., remain so that we are not able to fully be able to harness the energies of these young legal minds to produce both first-rate scholarship, first-rate journals. So I have no answers to this, but I'm just posing this as a problem. And I edited the Indian Journal, and I know what the problem is. So I'm not saying this without experiencing it. So I experienced the difficulties of running a journal, and another day I'll speak to that issue. Let me stop there.
So, do you want to respond to these two questions? Like the students have put out two specific titles. One is that how do we empower the disabled child through international law and primary schooling, and the other topic is the Ancestral Working Group 3's possible reform option of ISDS mechanism a viable theme. Any reflections on these particular themes? About do you see them as what would be your suggestions to make these themes better?
Yeah, no, on the first question, which I think is a very, very important issue of disabled child in school, I would leave that to Professor Dhanda to answer, because I think the person concerned obviously has some particular issue in mind, and I think she is an authority on this field. As for the UNCITRAL's working group 3 discussions, yes, I do see that as a viable project for doctoral or postdoctoral research, or even for writing a journal article. Of course, once you go to the discussions within the UNCITRAL working group, you will see that in order to write about the UNCITRAL working group discussions, you'll have to take into account so much else, but most certainly, the issues being raised in UNCITRAL working group are certainly a viable project for research. Professor Dhanda, would you care to answer this other gentleman who wanted to know about the child?
Trying to look for the question, but
It's
I
the
couldn't
first,
find.
first question. It's the first question. How can we empower the disabled child through international law and primary schooling?
Well, I mean, see, one traditional way, of course, is that the Convention on the Rights of Persons with Disabilities has got an entire article on the right to education. And it's got kind of the speaking in terms of what is it that you have to be guaranteeing to persons with disabilities, and especially also in the schooling phenomena. The thing that is more important to worry about, and I think that's the larger question that Professor Chimni has raised, that the incorporation of these rights within a convention, which is supposed to be hard law and hence you're bound by it, how much of that, how much of, let's say, there is runoff between what you have in a convention and what you can get on the ground. You can, of course, there are these whole range of traditional options that you can rely upon to be, like addressing this, that this is what the international law is providing for. These are the other kinds of options. This is what we're doing on the ground. This is one very typical kind of route. The other is to also start thinking in terms of, okay, what did you put there in international law? How much of like the variance which exists within the world got reflected in how you put those norms there? I have a huge critique in relation to, because ultimately that international convention is asking for reporting from the state, and you are then saying you're trying to work out key between what the state is reporting and what the state is doing, what is the gap there, and you use a certain kind of a name shame policy to kind of compel countries to conform to whatever they are required to do. The difficulty, of course, is that if you honestly want to be saying this, and this is coming in from my experience of trying to do the country report for India, and it was like that if you wanted to, they ask you in the guidelines, can you state exactly, take stock of your country position, say what is it that is required by the convention, what is it that is your own situation, what's the gap, and try to address it. If you sort of make an honest stock taking and you put it in your own state report, you find that becomes a basis for you getting pilloried. So you are not really asking for honest disclosure. I tried very hard, in my conversations with the ministry to say that if we sort of state what our difficulties are, then evidently we'll start pushing people to have that conversation. But their thing, and I said, if you don't do it anyway, it will come in the alternative report. And the entire ministry's attitude was, the ministry, the officials at the, at Geneva and other places, it's okay, let it come in the shadow report. But if we make a disclosure, then it becomes something on which we'll be hoisted ourselves. So when you start this conversation on what is it that international law can provide for, there is this one very standard thing of, okay, this is what the CRPD is saying. These are the concluding observations coming in from the treaty bodies. These are the other kinds of initiatives by which that child with disability can get a better deal. But there is the other question also as to, okay, how much of what you're putting into international law is also like marrying the grassroots situation in your own country? And is it really such an easy transplant? That's the way I would sort of say it. I don't really see it as just because you've got a convention, you've got a magic wand with which everything is going to get set right tomorrow. From a research dimension, I definitely do think that you need to be asking this further kind of question on, okay, how reflective it is of what the situation on the ground is in your country, in what you have put into a convention. Something, and I'm sort of in some ways, echoing a point which Professor Chimni was making in his primary presentation, where he spoke in terms of how human rights is being constantly seen as this ultimate panacea. I mean, you were sidelined by a particular system, and then you believe that the human rights which are being articulated by that same system is going to provide you that, that route of inclusion. Is it really going to do so? Can you be seeing human rights and struggle and movement work and other things as interchangeable? Or that would be my worry kind of things.
So I think the other question which is related to, this narrowing and keeping your question, how do you narrow down your topic, or how do you make sure that, you're taking in the adequate amount of depth. I think a constant problem that we're also seeing, particularly with international law, is that now, like constitutional law in that sense, international law is everywhere. Almost everything, there is a dimension of international law attached to it. And this is also related to this question about the disciplinary boundaries that we talk about, and where we're talking about now disciplinary boundaries also being blurred, at least. And for example, when you talk about the primary question for international law was the question of the state, today when you talk about corporations being something that international law has to deal with, how does one negotiate these boundaries? Because what I'm trying to say is that sometimes you see a lot of theses in which there is a chapter on international law. So it's become like one stock thing that has to be there in everything. How do we avoid that? At the same time, how do we ensure that this is primarily a dissertation in international law, and how do you avoid not trying to do both municipal legislation, international law, everything in the same one? I think that is again a balance that is quite difficult for a lot of people.
Yeah, no, you're right. There are a number of sort of boundaries that one has to one encounters, and one has to negotiate how to deal with those boundaries. For instance, one boundary which you mentioned in the beginning was that when you think of international law, you essentially think of what I call the logic of territory, or the sovereign state system. That is, that there is a very, very intimate relationship between the sovereign state system and the evolution and development of international law. This is the routine thought that informs much international law scholarship, informs textbook. Yet there is another dimension or another relationship which is as significant, but which have been passed over by scholarship over 3 or 4 centuries, which is what I call the logic of capital. That is, there is, in the same way as there is an intimate relationship between the sovereign state system and the evolution or development of international law, there is an intimate relationship also between the evolution and development of capitalism and international law, so which I call the logic of capital. Now, the logic of capital has not been discussed in much of the global north literature, because it inevitably leads you to a discussion of the colonial project and the neo-colonial project. So it is invisible. The logic of capital is invisible. Yet you take any aspect of international law, it is governed by the logic of capital. Today, of course, there's a full-fledged branch called international investment law, which essentially facilitates the interests, the realization of the interests of global capital or the big transnational corporations, etc. So, in other words, there are some artificial boundaries that have been created. And one artificial boundary is that you don't look at the logic of capital, you only look at the logic of the state. And which is deeply problematic. You cannot understand the relationship between global north, global south without talking about capitalism. And one has to negotiate this relationship, which is what one is trying to do through one's work, and there are so many others who are doing the same. The second kind of boundary is the boundary between municipal law and international law. My own sense is that these boundaries have greatly blurred, where core concerns of national interests are concerned. So there is almost no boundary where, say, economic decision making is concerned. So most of the sovereign economic decisions are today in some form or another regulated by international law and international institutions. To give the most well-known example, you cannot have your own intellectual property right regime because you are party to TRIPS, and whose disastrous consequences we are now seeing, because India and South Africa, along with 100 states, no less than 100 states, are asking for a waiver in the WTO TRIPS Council, so that vaccines can be produced at a higher volume and therefore made easily accessible. So where is our sovereign? So you take investment, we are regulated by international law. You look at environment today, most aspects of environmental are regulated by international environmental law. So my sense is in core areas, this distinction has blurred. But often this blurring is not easily identified, because most researchers who are researching in the legal domain within the country encounter international law in the form of domestic law. So they see it only as domestic law. So TRIPS will be seen as Indian Patent Act. TRIPS will be seen as Indian Copyright Act. International environmental law is encountered as Indian Environmental Protection Act. So because you encounter them, or WTO law is encountered as Indian Customs and Tariffs Act. So because you encounter them at the domestic level as domestic legislation, you do not think these are international law. Actually, much of this and the consequences of these are enormous. I won't go into. So that's another boundary. So my feeling is that when somebody says, I'll put one chapter of international law on this, it is possible with regard to some areas. For example, if you are researching, say, something like the role of the public prosecutor, then of course you can have a chapter on what international law says. It has something to say on that, the codes of conduct, the protocols, etc. But on very central issues, my sense is this is not possible, because they are entangled in ways that you cannot sort out the influence of one without sorting out the influence of the other. So they have to be studied integrally. They have to be studied as one movement rather than simply. How it is done in practice, that can be worked out. Sometimes, the chapterization has to assume one form or another form. But on a conceptual level, I think those boundaries have blurred. And the third kind of boundary is the boundary between disciplines. Again, like I said, I think you can do very good research staying within the boundaries. That is, even if you're a formalist, positivist scholar, I think you can produce very good research. Say Sirwai's book on Indian constitutional law is a worthy product. Although you may not know much about why the constitution came into being, what are the values, aspirations, but in itself, it is a very worthy project. So you can produce excellent work within positivist law. But my sense is today, there are very few doing positivist work who are also not in some form interdisciplinary in their orientation. It is only the question of, some are 90-10, some are 80-20, some are 50-50. But there is no way, because it's the work, it is the subject we are researching which is interdisciplinary. It is not that we are bringing a method to the understanding reality. The reality itself demands. For example, climate crisis unites humanity. Nobody could have united humanity in a way that the climate crisis itself is. In fact, we are introducing disunity. So sometimes the reality itself is able to define the boundaries of method. But I have no issues. So these are some of the boundaries you negotiate. And again, there's no formula in negotiating these boundaries. How much of capital, how much of sovereign state system you want to use will depend upon the nature of the subject you are researching. Some are more accessible to one logic than to the other logic. But yes, you need to keep this map in mind, that there are these various boundaries that you have to negotiate, and you have to thoughtfully, self-consciously negotiate, because if you don't do that, you might sort of lose out on a rich resource which you can tap into for doing your work. Yeah, I'll stop there.
A similar question is a question which says, when you're researching historical topics and issues, how fair is it to examine an issue from the perspective of present international law? Is it not doing violence to those actors involved who are part of that act in terms of establishing their responsibility or liability? Since they did not have the luxury of seeing things in hindsight.
No. I think now, so that's a good question, but my sense is now, again, if you look at the emerging international literature, there is a growing consensus that you cannot understand the present, the very commonplace platitudinal sentiment that you cannot understand the present, whether an individual regime or a doctrine or a category of international law, without understanding the genealogy of that doctrine or practice or regime. Genealogy is very key, especially from the global south standpoint, because unless you do a historical analysis of these doctrines and their emergence or the emergence of particular practices, say in investment law or in IPR law or human rights law, you cannot really understand the ideological baggage that they often carry. And this ideological baggage can be biased and prejudiced against both weak states as well as weak groups and communities. I want to mention that all the time. So, to my mind, history is very, very critical. Now, what has happened is that we have done the big history. So, 12, for example, the first generation of scholars, whether it be my own teacher, Professor Anand, or his generation of scholars, Judge Nagendra Singh, they did that initial hard work of trying to do two things, showing the Eurocentric nature of the history of international law on one side, and on the other side, Judge Nagendra Singh showing how these practices, international law practices, were part of Indian civilization, and to claim that international law is simply a product of European Christian civilization is all besides the point. Subsequently, this historical narrative, critical narrative, has been carried forward by scholars like Anthony Angi, my friend, who has tried to show how that this whole colonial idea infiltrates every aspect of international law. But what remains to be done, and which is where we require much more historical work, is, for example, the history of different doctrines of international law. What is the state responsibility? For example, what do you mean by sources? Often we will find that if you trace it enough backwards, the sources can be theological. So in fact, on many counts, the sources are theological sources, which were at some point secularized and then turned into doctrines of contemporary international law. And if you want to then offer an alternative understanding of these doctrines, alternative formulations, you cannot do it without actually identifying those elements and components of the doctrine which have this continuity and which need to be reconfigured, removed, or sort of reformulated. So for me, the historical work is not simply about the big history. I think we have done that sufficiently. The feminist critique is also emerging. How history of international law is almost like reading the history of men who did international law. But what we have still not been able to do, because it requires an enormous amount of labor. What was the genealogy of these different doctrines? How they evolved in response to what kind of interests of Europe at that point of time, and what kind of interests do they serve even today? Say jurisdiction. The whole idea of extraterritorial jurisdiction has not been really explored from a global south perspective. For example, most textbooks will tell you it is an exception to the rule of jurisdiction. But I've argued, I hope it will be published in the future, recently in an article, that actually that's not the case. Much of the law of jurisdiction is all about extraterritorial jurisdiction, which is what colonialism was, or semi-colonialism was all about. So, but that you can do if you only dig deep enough. Of course, we need to be careful that we do not that we are not dismissive. So many of the old doctrines which have undergone some amount of change remain useful. Some of these are procedural doctrines. They are procedural, rules. They may still continue to be useful. After all, we are also using procedural rules which were part of the colonial, legislations. The short answer is no. History needs to be done. It's very important. Not history in general, which people are doing, but that's the problem. I think this is a problem not only with history but theories. I often find people will say in their thesis, I have a twale or a feminist or an X perspective. And then after the first chapter, they leave that behind, and the rest is along familiar lines. Familiar lines. What we need to do is integrate our critique so that what we say in our chapter 1 should also be reflected in the subsequent discourse. So in short, I would personally believe that you need to get into serious history in order to study any area. I'm talking now about any area of domestic or international law. You need to do this. The genealogical exercise has to be done.
So there is another question which says, particularly with reference to the governance of global commons, what are the ways in which you think the global south can contribute in ensuring democratization of outer space?
Yeah, so that's a good subject for research. How do we democratize in the face of power and in the face of underdevelopment? And so there are many efforts which are ongoing efforts. Climate change is one. We've seen how the global south came together in order to be able to inscribe the principle of common but differentiated responsibility into an international law text. But we saw that process of democratization has faced a setback in my view, in the Paris Agreement, where slowly, this principle is being diluted uh, by several moves. One is suggesting that we don't have to look at the past historical responsibility for global warming. It is all about who's warming the planet today, and that is being done by emerging nations like China or India. It is done by including some form of informal form of international supervision through creating this idea of nationally determined contributions in the Paris Convention. So 2 points. One, this is global commons is a vast subject. That is one, we have to identify where the inequities lie. What part of the global commons regime is unfair, is iniquitous, Second, are there forums, processes in place which would allow a dialogue between different, takes on this problem? And third is then to find, to look for principles, rules. To find the normative basis for reversing those inequities. To take an example from international trade law, the principle of special but differential treatment, likewise, like common but differentiated, was a move in order to lend equity in the field of trade law. But it has been circumvented again by power through subtle and not so subtle means. Likewise, in the case of global commons. So, to put it differently, what we require are concrete analysis of particular regimes to identify areas of inequity, unfairness, and injustice. And then you will have to try and see what are the ways in which you can address this in the language of international law. So we are talking only of the language of international law here. There are, of course, other ways of also doing this, but so that would be my suggestion.
With respect to the other question, I think what you just ended with is very relevant. That is, do you want it to be an international law project, or should it ideally be a project in perhaps something else? Like, for example, there is this candidate that's looking at digitalization in a particular sector. Now, when we're talking about, and she's saying that she's finding difficulty in finding data in that aspect. So how does one determine that these are good areas for an international law research, or perhaps they should look at other disciplines?
My sense is that you should stay with that area which sort of you find interesting. Like I keep saying, you have to working in an area is like being with a friend. If you don't like the friend, you're not going to stay with the friend for 4 or 5 years. So stay with that area. But for example, the digital sort of universe, there are so many dimensions to it. One dimension which is right now, at least in the last 3 months, which has gained very much prominence, is whether we can leave, say, digital companies to self-regulate. So there was the decision, I think it was in May or June, of the Facebook Oversight Board on the Trump case. And Facebook has adopted its own human rights policy, which then appointed a Facebook Oversight Board, and the Facebook Oversight Board then took up the Trump case and has suspended it for his account for 2 years. It was already suspended, they have extended it to 2 years. Now you see in India the whole issue raised with Twitter, that Twitter is self-regulating. Twitter says, I have some policies. So Twitter is a private company. It seeks to self-regulate uh, in the context of the policies it adopts. Now, what are these policies? Are these policies sufficient to safeguard basic rights available in the Constitution of India? Uh, so one big question is, say, self-regulation. Is it good enough or not? That's one kind of question. Second kind may be very narrow in the scope of the study. Like, for example, you can write a thesis on facial recognition, artificial intelligence, facial recognition, and international law. And there's a lot of literature that is emerging, because it will be, there is no doubt, it will be increasingly used by authoritarian states to suppress dissent, to suppress movements, etc. And this is not very far off. We are talking about here and now. And that's why if you read the statements of the UN Secretary General, which is almost like an apolitical position, most of his statements are very alarmist, because he's really concerned that. So my sense is that if there is a particular area of the digital universe that you are seeking to research, which you are finding it difficult in the absence of access to the right literature or access to the right data, because data is not also easy to come by. I don't know if you read that even NYU, their project has been shut down by Facebook. I think it's Facebook, the NYU project, because they were seen to be gathering some data. Likewise, there is a small NGO called Algorithm Watch. I just read that their project to study data has been shut down by Facebook threats of taking legal action. So there is a whole range of literature, and I would suggest to this whoever asks this question that do a careful survey just using the internet, and I'm quite sure you'll find enough literature in the area that is of interest to you. And I would encourage you to study it, because I think technology, I'm not a technology determinist, so I oppose technology determinism, but technology is going to crucially shape our future. In the next, I'm too old to be there 2 decades later, but you will see that within a decade or two, our worlds are going to be transformed by technology, used by capital. So there is that marriage between technology and capital. And therefore, it's very important, wherever you begin, whichever slice of the digital universe you are analyzing, that do it despite the initial. I mean, that's the wonderful thing about research, that you start from nowhere and then slowly build and have something to say. What's the point of researching? So a lot of people ask me IPR, and I said I'm tired, because everybody wanted to at one point only research IPR. Labor law, nobody wanted to research. So, and I said, but why? Labor law is where the real thing is. Yeah, but I would encourage the person to research, irrespective of the obstacles. And if there's obstacle in one little area, move to another one where it's sort of more accessible, the literature and the data.
There is another question on how do you perceive the future of the legitimacy of dispute settlement bodies, such as the WTO panels, ICSID, and other bodies in the pandemic era in terms of increased, decreased disputes and engagement? I think this is coming in the context of the post-COVID crisis, where there have been at least 12 WTO disputes initiated since the pandemic.
Yeah. So my sense is that nothing dramatically is going to change in the area of dispute resolution from how it is today. So there has already been some change from initial post Second World War decades, in the sense that we have many more international tribunals today. There's a proliferation in international tribunals. So whether it's sea, whether it's trade, whether it's commerce, there are international tribunals in place. And second point I would make is it depends on the nature of the dispute. So what are the dispute you're talking about? If you are talking about disputes which are about the core national interests of a particular nation, then dispute settlement will never work. So you can't force China to accept the decision on South China Sea because it thinks it is its core national interest. I think that the international law is not so difficult to interpret, but China refuses to accept it because it sees it as a core national interest. The United States walked out of the International Court of Justice's compulsory jurisdiction several decades ago because it didn't like what the ICJ said. So the basic core argument of what we call the realist theory of international law, or the realist theory of international relations, first articulated by people like Hans Morgenthau. So they made the point there that these dispute settlements for major powers will work only when it involves peripheral issues. But for core issues, once, so there is the famous statement of Morgenthau that there is the iron law of politics, that international law always yields to national interests. But that's applicable to only the big powers, not to us. We can't do that. If we say we go to hell with WTO, no, they'll sanction us. But Trump could do that. So in other words, to answer your question, you need to be a little familiar with the different theoretical outlooks on dispute settlement. One is the liberal outlook advanced by Lauterpacht and others. Then there is the realist outlook, skeptical, Morgenthau and others, and so on. And they'll offer you different answers depending upon the nature of disputes. You must remember that WTO is only one where there's compulsory dispute settlement in a sense. Rest is always optional. States are free, to decide what disputes they want to settle through international mechanisms and what they can't. But again, a good area of research, and in this case, there is endless literature available.
Taking on from your response to this question about how does one even approach the whole business of dispute resolution, I wanted to come to the last question that we have here, which is something we were speaking about in the last session where we talked about corporate law. And it's a project both me and Professor Dhanda are working on, which is how does one teach labor law? That the teaching of international law, evidently, and the kind of research that you want to do in international law are closely connected. And there is a question here which is saying that obviously the teaching of international law seems to be very divorced from the realities of international law. Then how does one bridge that gap?
I think the teaching of international law often seems divorced from the reality, is because of the materials we rely on to teach international law, and that's why the pedagogy of international law itself needs to be decolonized or revolutionized or whatever. But we again at our end need to put in enough labor on that front. Uh, and so, to put it differently, the standard textbooks on international law, those materials make us alienated of, from the international legal process, because it doesn't say anything to anything to us. And that is why it's very important to do international law differently, to use a different set of materials which is able to connect people. So for example, if the caste question is being discussed by sociologists, by anthropologists, even by economists, by political scientists, it's absent in international law. There's no reason, because there are conventions in place which cover the issue of caste, elimination of racial discrimination. Now, how do you draw that into the pedagogy? All of us use Amazon or Google or whatever, these digital platforms. So if there is something in the pedagogy which speaks to these issues, I think it will connect with us. The problem is that some of the aspects that are covered by the standard textbooks are archaic, and don't speak to us, don't speak to our world, and therefore it's very difficult. I know I faced this initially as a student in the 70s, when all these approaches had not come. There was just one way of looking at international law. It was very alienating. While my friends in other disciplines were discussing this, post-colonial theory, and in what ways we can transform our worlds, bring about social transformation, etc. These issues were not there part of international law. So, in other words, that theory and practice are divided because of the pedagogic materials we use. The second is also an equally important divide between theory and practice, and which is to say that often often individuals, who do international law or teach international law are unable to connect their theoretical inclinations or predispositions with the practice of international law. There's a disconnect. And because of that disconnect, it appears that, so somebody will ask you, so what do I do with postmodern theory? What does Foucault or Derrida have to say to my concerns? Or what do they have to say with this X topic of jurisdiction or state succession, etc.? So I think this is also disconcerting, because if you are going to tell people a theoretical position on the subject, but are then not being able to, in a sustained fashion, connect with the other areas of international law, that is the practice of international law, then there is going to be this, then you are going to encounter this problem where, instead of actually making students engage with theory, you will alienate them from theory, because it's simply seen as an elitist move. It is simply seen as an elitist move to say, look, I can do this stuff that you can't, and that I have read some 3 things that you haven't. In other words, this relationship between theory and practice has several dimensions. I won't get into them. So it all depends on whether you are able to connect the world of theory and practice in a way which is illuminating for the student, for colleagues, will depend on how it is how it is responded to. But again, these are very important questions, and we need to keep thinking about them.
Are we done, Vasanthi?
There are quite a few questions still here, but I think each of them are requiring a kind of a exposition on all of them. So I was wondering how do we
I
complete?
think there are some very specific kind of questions that people are asking for particular areas or something
Yeah,
like that.
yeah,
So maybe what we could do is just about another 15 minutes, like each of them asks in as simple a possible
yeah, yeah,
the question directly to Professor Chimney.
yeah.
And
Yes,
because I
I'm
think,
happy to
and
go
what,
along.
just for saving time, maybe it might work that if you ask those questions one after the other and then let him respond, because it's too particular and one can't really, it's not fair, to then sort of expect him to respond in that manner. That would be my take on it. At the same time, we don't want to be gagging you, and many of you are here because you want this personal encounter with Professor Chimney. I don't want to deny you that. So I think we're going to do some kind of a halfway house. That's
Yeah,
so
so
you.
it's an open house. So anybody who has a question, but keep your question narrower. Don't and something that will be relevant for everyone else. So you can unmute yourself and ask the question.
All right, Rahul, go ahead.
Yeah, sir, I wanted to ask you about issues of representation
Can
and
I see you,
equity.
Rahul, if you're
Yes, sir.
comfortable with it?
Yes, sir. Yes, sir. Okay. I don't know
Okay.
why the face is not showing up, but so I was just wondering about the issues of equitable representation in international organizations, not just of states, but also of non-state actors and how they are being represented, how this, how far their involvement in the process of international lawmaking is equitable. This is something that I was thinking to research on. So I just was hoping for some inputs on this.
Okay. So quick response to that is there's enormous amount of literature on the question, on both this question, on the question of representation of civil society, non-governmental organization within international organizations. They find representation, of course, in the United Nations and in a whole host of other organizations. In fact, there is very few international organizations today which do not have engagement with the non-state sector in one form or another. Very often they are given formal, their status is formalized within international organizations. So that is one aspect on which you'll find a lot of literature. The UN has drafted rules, for decades now, on the basis of which accreditation is given to non-state actors. So that's one kind of issue, formal representation within international organization. A second kind of issue relates to the role of civil society in the advancement of international law. So there are now, including convention, which have been adopted at the initiative of civil societies. In fact, some of the human rights conventions, including the declaration, say, on rights of indigenous peoples, wouldn't have come about without the active participation of the civil society sector. But they have also proposed conventions which have been adopted. One such is with regard to landmines, for example, was proposed by a drafted and proposed by a civil society organization. The one on peasant rights is also largely, effort of the civil society. So, in short, the role of civil society in international law is today a very, very important one. Now, the second point I want to make, because I haven't done this till now, is that from a 12 standpoint or other critical approaches standpoint, the role of civil society is very important in terms of the legitimacy of particular international rules or international legal regimes. And the argument is that even if this is a Habermasian kind of argument, that even if a particular treaty is adopted or declaration is adopted, it may lead to creation of valid international law, but not necessarily legitimate international law. The legitimacy would depend upon its acceptance also by the global civil society. And if there are social movements which are questioning, for example, on the TRIPS text, then it undermines the legitimacy. So at all three levels, at the level of representation, at the level of rule formulation, and at the level of sort of rule questioning, the civil society is playing a very, very important role. And I think this role is only going to be enhanced in the future when we find more and more states giving up on democratic rule.
Thank you, sir.
Yeah, anyone else? Anybody who feels that their concern has not got addressed, this is your chance. Okay, I think this has been a really, really energizing and a very, very engaging morning for all of us in several kinds of ways. And also, like, one more time, one has come to realize this close relationship also between teaching and research, or between the kind of materials that we produce and what further materials will come. And I think that's exactly the kind of challenge that, okay, if we are having a difficulty or a problem with how things are, then all of you who are deciding to do research now, it's like for you to take that, like crusade further as to what you produce, so that this inequity this intellectual kind of inequity that you see, you actually recognize it and address it instead of just becoming like complicit with it. I think for me, that is the biggest message that comes through with all that Professor Chimni has presented and the answers he gave to the various questions. It kept coming back to that, yes, okay, this is not right, but we can't just be like, it's like, what is the candle that we are lighting? We just can't keep cursing the darkness. It's that kind of a thing that at least came to me. And that is partly the reason why we are doing these workshops, because we feel that as younger, all of us in our own times, that once you stumble along, by the time you realize that, oh, this is something that you could be researching, a lot of water has flown. So it's helpful to be given some kind of mentoring and guidance. Okay, there is an entry point here. Why don't you look at it? And I think Professor Chimni has done an amazing job, as was expected. And that was the reason why we were so very grateful when he accepted our invitation. And I think all of us who've been here with you have found this to be energizing and thought-provoking in so many sorts of ways. Let's hope that it kinds of also results in action at several levels, in the kind of proposals that you make, or fine-tuning your own proposals, as well as I would, Professor Chimni, want to really very seriously, like for us maybe across schools, to start thinking in terms of creating those kind of journals and publications which are, like worthy of the sort of scholarship that we want. To actually invest in it. And more importantly, I think somewhere we would need to sort of address this wrongful way of practicing kindness, in relation to scholarship, where we believe that giving people, degrees too easily or too early, without insisting upon that kind of rigor, is being kind. I would say that it's being kinder if you insist upon that, no, the work has to be at a certain level. And if we are talking about third world approach to international law, then the third world has to sort of like produce the sort of material on a constant basis, and not just by one scholar here or there, but in that level of volume and scale that you can set up the challenge. I think it's your both, like looking at international law, old and new, both are giving us, at least gave me a range of things on which work can happen, and I'm certain that scholars here would have equally benefited. We would like, I just wanted to say as an A-side point, because it's something I've been forgetting to do, it'll be good if you guys were to sort of feedback on what these sessions have been like, because once you go away, it also helps us to work out what more we could be doing, or how you learned from whatever came in or happened today, both from the particular session as well as from the series that we are running. And so with these words, I want to thank all of you. Thank you, Professor Chimni, again. I'm hoping that, I can keep roping you in one way or the other with helping this entire research enterprise, both at Nalsar and everywhere else, because it's not, the people who are registered for this course are not limited to Nalsar. It's an open registration. People are coming from all over. It's a kind of exercise that we're just setting up a conversation, saying that yes, to do research also on what you should do research is in itself a research topic. So start thinking from there. Don't work out don't settle up a topic, go get registered, and then start thinking whether this is worthy of research or not. That seems to be one of these stumbling blocks we often find. So we're trying to remedy that by having these conversations. And also very often questions that young people ask trigger thoughts in one that, oh, I didn't think of it in this manner. Maybe this is something one can look back and, I'm sort of seeing it as mutually beneficial kind of stuff. So thank you, everybody. Thank you, Professor Chimni. Thank you, Professor Vasanthi. You had a real onslaught today, but I think you did a very, very competent job in how you kind of clubbed the various questions to see that nobody felt that their concern was not addressed. So thank you all. And we have a human rights session next week. So again, look forward to seeing you. We have one on human rights and the last one on researching in disability. That's the last one in this series. And subsequent to which, so it's a good time for you to start feedbacking to us, because as we are going to be designing further work, it'll be good to know. One of the thoughts is that instead of running it like a big festival, it may be good to do maybe one session of flying kites every month, and not just fly at Sakranti kind of things. That was the idea basically. So, but some feedback on that count will be helpful. Somebody is saying maybe materials could be provided before and stuff. I just responded to that person saying maybe later, but at least, let's be satisfied with what we have. If you're getting the best people, it's not so easy for, people finding time to do that kind of exercise also. So I think it's been a very, very rewarding morning and a great, what should I say, pre-Independence Day celebration. Okay, bye-bye. Thank you.